morning, please.
Good morning, one and all. I, Vedant Vaishali Jayant Mainkar, has the distinct joy to welcome you all for the public lecture, I should say, for the historic public lecture on the 50 years of basic structure doctrine, revisiting Kesavananda Bharati versus State of Kerala, organized by Maharashtra National Law University, Mumbai, in association with Center for Public Law and Jurisprudence and Internal Quality Assurance Cell. I welcome you all. Maharashtra National Law University, Mumbai, established in 2014, is one of the premier national law universities in India. Honorable Chief Justice of India, Justice D.Y. Chandrachud, is the Chancellor of the university. Our Vice Chancellor, Professor Dr. Dilip Uke, a renowned academician in law, having varied experience in teaching and research, is our luminary. Our pillar, our esteemed Registrar, Professor Dr. Anil G. Varyat, supports us through his vast network, resource, administrative legal practices, experience. Center for Public Law Jurisprudence has been recently established by our Honorable Vice Chancellor of MNLU Mumbai with the goal of unifying all scholarly research and with the goal of unifying all scholarly research and educational initiatives pertaining to past, present and future legal developments of public law and jurisprudence under one umbrella. About the public lecture. Dear all, on 24th of April 1973, two important things happened in India. First, the god of cricket, Master Blaster Sachin Tendulkar, was born. Second, on the same day, same year, the historic judgment of Kesavananda Bharati case was delivered. And of course, it's just like Master Blaster Sachin Tendulkar. It had a vast impact on Indian constitutional law jurisprudence. And this case is unique in itself. This case lasted for 68 days, around 100 plus constitutions were referred, 100 plus judgments were referred in the court, and a 13 judges bench sat and delivered this judgment. Of course, this case had a large impact on constitutional law jurisprudence. The tussle between the apex court and the parliament, which started from the very first amendment of the constitution by Pandit Nehru in the Shankari Prasad case, then Sajjan Singh, I.C. Golaknath, was finally settled in the landmark case of Kesavananda Bharati versus State of Kerala. Many historical judgments till present, even after the 50 years of this case, still revolve around this case. For example, the most recent one in 2022, the EWS reservation case, which of course again revolves around the basic structure doctrine, or maybe the Aadhaar judgment, the NJAC, which was recently in 2017. These all judgments revolve around the historic doctrine of basic structure. What exactly is doctrine of basic structure? It essentially means the court said that Parliament can amend any part of the constitution but not the basic structure. To dive more deeper into this entire nitty-gritties of this judgment and to celebrate this 50 years of its judgment, we have with us Professor Dr. V. Vijaykumar, Honorable Vice Chancellor of NLIU Bhopal. With this, I request Honorable Vice Chancellor Sir Dr. Dilip Uke to felicitate Dr. Vijaykumar. Thank you very much, sir. Now I request Honorable Vice Chancellor, sir, to have the presidential address.
Chief guest of today's program, my long-time friend, a philosopher and guide, a well-wisher and supporter of Maharashtra National Law University, Mumbai, a great human being, Honorable Vice Chancellor of NLIU Bhopal, Professor Vijaykumar, Registrar Dr. NLIU, HOD Dr. Kiran Rai, Coordinator of the Center Dr. Salunke, all other colleagues and dear student friends. A very happy and good morning to all of you. Before I say anything about today's program, let me add a few words about Professor Vijaykumar, the senior most jurist amongst the current ones. Having a vast and varied experience of founding faculty of first National Law University, which was established in India, Bangalore, served as the Vice Chancellor even at Madras, Chennai now, and then now heading Bhopal, who contributed and is contributing immensely in the legal education, in the cause of legal education, by way of his lectures, by way of his writing, and by way of his guidance to national law universities as well as to the law institutes and law colleges. When we thought of holding the public lecture on account of 50 years of judgment delivered by the Supreme Court in Kesavananda Bharati and Doctrine of Basic Structure, we have not ever thought about any other name than Professor Vijaykumar. Rather, program was to be conducted much earlier, but because of his very busy and tight schedule, rather dates were shifted twice, and we thank him for having accepted our invitation and welcome him on behalf of the university, faculty and students. As he has pointed out that recently we have established the Center of Public Law, Research in Public Law and Jurisprudence, as well as the public policy. The reason is that rather the nomenclature was changed. Earlier it was Center of Research in Constitutional Law and Jurisprudence, that has been changed to Public Law and Jurisprudence, so that center can take care of allied disciplines, allied subjects of public law discipline as such. Main goal of the center is that several issues which are being faced today in a contemporary period. If we talk about constitutional law, the issue of collegium, I need not have to say anything. The issue of reservation, the issue of hate speeches, same-sex marriages, so on and so forth. So what is needed is, or even issue of defection or anti-defection, which we experience and witness. What is needed is a proper, deeper research vis-a-vis these issues are concerned, and then to conduct that research, carry out that research and bring out some monograms, booklets and undertake the research projects, including the way and the manner in which judicial process is being conducted nowadays in past 1 decade or 2 decades, and particularly in recent period of time. With that goal, with that aim, we have established this center. As Professor Vijaykumar is going to speak about basic structure doctrine and Kesavananda Bharati judgment, I do not wish to commit any constitutional trespass. Yet there could be some breaches, small breaches about the domain of Doctrine of Basic Structure and Kesavananda Bharati. I would refrain rather much. As he has pointed out that Kesavananda Bharati versus State of Kerala, AIR 1973, Supreme Court 1461, the judgment which was delivered on 24th April 1973. The doctrine of basic structure, which has been rather evolved by the Supreme Court, whether it is novel, innovative, or the instance of judicial activism, or the facet of constitutionalism, Professor Vijaykumar would dwell upon that. Even including the political history, not pure history, political history, behind and post Kesavananda. However, just as a note of addition, if one reads the judgment, original judgment, one would realize that judgment was delivered primarily 6 versus 6. It was evenly split. 13 judges bench, a largest ever bench, which was divided evenly, 6 versus 6. It was only concurring judgment of Justice Khanna which has tilted the balance in favor of the majority, so-called majority. However, if roots of the basic structure doctrine, if at all they are to be traced in India, to my mind, they could be traced in Sajjan Singh itself. In the dissenting judgment delivered by Justice Mudolkar in Sajjan Singh. Those two dissenting judgments delivered by Justice Hidayatullah as well as Justice Mudolkar reflected subsequently in Golaknath and Kesavananda respectively. It was Justice Mudolkar who had said in his dissenting judgment in Sajjan Singh itself that there are certain basic principles, he did not use the term features. And that's why if at all any credit is to be given for the basic structure, it is Justice Mudolkar who really deserves that. Sometime minority judgment or dissenting judgment become the majority in future. They become law of the land. That is one. Secondly, in Kesavananda, judges, some of the judges, they have appended the summary to the judgment. Whether that summary is a part of the judgment or not, that nobody knows. That is a matter of great scrutiny. Whether it is really formed the part of the ratio or not, that is matter of really a great scrutiny. That is another thing. Thirdly, understanding of the doctrine of basic structure or misunderstanding of the basic structure doctrine, not only by the students, not only by the faculty, not only by academia, even there was a kind of a misunderstanding on the part of the judges as well. As in Kesavananda, as I said, that court was split, bench was split 6 versus 6. It was Justice Khanna's concurring judgment tilted the balance in favor of the majority. In Kesavananda, Justice Khanna had said that in his concurring judgment, that right to property, which was a fundamental right then under Article 19(1)(f), is not the part of basic structure. What Justice Khanna has said therein, Kesavananda, was that right to property, which was a fundamental right then, is not the part of basic structure. Some high courts, and then thereafter, and particularly Andhra Pradesh High Court, undivided Andhra Pradesh High Court, in Venkat Sheshamma versus AP, Andhra Pradesh. Judges said there that misinterpreting, that's how I said misunderstanding. Misinterpreting Justice Khanna's judgment that Justice Khanna has excluded whole gamut of fundamental rights from the purview of basic structure doctrine. And that's what. Understanding, interpreting doctrine of basic structure is very, very important one, necessary one. Rather, it was Justice Khanna again in election case, Indira Nehru Gandhi versus Raj Narayan, 1975. AIR 1975, Supreme Court 2299. Therein, Justice Khanna had to clarify his stand taken by him earlier in Kesavananda. On record, he said that what I mean and what I did was in Kesavananda was only to exclude right to property from the purview of basic structure, not the whole gamut of, not from the whole gamut of basic structure, not the whole gamut of fundamental rights as such. So these are the issues, or rather there are several issues or the difficulties which are there about the interpretation, analysis and understanding and interpretation of doctrine of basic structure. It has completed 50th birthday on 24th April. Basic structure doctrine has celebrated its 50th birthday. Rather, we wanted to hold this lecture on the same day, but somehow, as I said, that we could not do that. I am really happy that Professor Vijaykumar sir has accepted our invitation, though not on 24th April. Today is 3rd May, just a week thereafter. With this, once again, I thank him and welcome him on behalf of the university as well as faculty and students. Thank you so much.
Thank you very much, sir. Now I request Honorable Registrar Sir, Professor Dr. Anil Variyar to deliver the welcome address.
Respected Chief Guest of the Day, Professor Vijaykumar sir, respected Vice Chancellor, Professor Dilip sir, my dear colleagues and students. There is no relevance for a welcome because Professor Vijaykumar sir is no stranger to us. Right from the day university has established, he has been with us, guiding us and giving us advices and everything. And listening to Vijaykumar sir is always a matter of enrichment. And I must congratulate our Vice Chancellor sir for inviting the most appropriate person to deliver the lecture on the most appropriate topic. But I would like to take 2 minutes because the subject of the day is very close to my heart because of few reasons. One, Professor Kesavananda Bharati belongs to my state. Dr. Swami Kesavananda Bharati belongs to my state. I had occasion to see him even before I heard of Kesavananda Bharati case. I heard of Kesavananda Bharati case and I read the Kesavananda Bharati case when I was doing my BA Political Science in Usmania University, Hyderabad in 82, 83. And thereafter, after becoming a law student, after becoming a lawyer, I had occasion to listen to Kesavananda Bharati in the Government Law College, Calicut. And also an occasion to visit Edanir Mud where he was there. So, but right from the day I came across with the subject of Kesavananda Bharati case, I had a different view. I must tell you, I asked one question when I was in the BA class to my professor. My question was this one, of course, taking the lead from the judgment itself. Is it proper for the court to decide upon the validity of a law based on the spirit of the constitution, which a section of the judges feel it should have been perverted the constitution, which is not manifestly written in the constitution? A question of this sort coming from an undergraduate student was considered as a very immature and improper question, and I did not get the answer. The same answer I put in the LLB class also. Since my specialization was constitutional law in LLM, the same question I put in the LLM class also. I don't get an answer. And as a professor of law, I put the question to myself. Still I don't get the answer. And now, as a last resort, I look upon to Professor Vijaykumar sir for this answer. With this, I extend on behalf of the entire Maharashtra National Law University family, I extend a very warm welcome from the bottom of all our hearts to Professor Vijaykumar sir. Thank you.
Thank you very much, sir, for your address. Now to dive deeply into this understanding of doctrine of basic structure, to understand what impact this basic structure doctrine had in our governance also, as you all know, on 26th of April, Justice A.N. Ray was elevated as the Chief Justice of India, surpassing 3 judges. What impact it had in Indian politics, and to of course understand what significance this doctrine has. I would like to quote legendary constitutional law scholar H.M. Seervai, who changed his opinion on doctrine of basic structure after the horrific tyrannical emergency, and where he said doctrine of basic structure will make the bar and bench illiterate. So I would like that Professor Vijaykumar also enlightens us with this on this quote. To just brief about Professor Dr. Vijaykumar, is the Vice Chancellor of National Law Institute, University of Bhopal. Sir was a Professor of National Law School of India University. Sir was appointed as the Assistant Professor at NLIU in 1988, as the Associate Professor in 1992, and Professor of Law in 1997. Prior to joining NLIU Bhopal, Sir was the Assistant Professor of Political Science at Presidency College at Madras between September 1978 to 1998. Sir was the Registrar of NLSIU Bangalore between 2005 to 2008. Sir serves on various distinct panels and is also on the board of NLU Delhi. His areas of specialization include constitutional law, administrative law, human rights law, law of elections, humanitarian law. Sir has held the UNHRC chair on the refugee law and has keen interest in IT administration infrastructure. So we are honored to have you here, and we are eager to your valuable words on this historic day, on the historic occasion of this historic case. Thank you very much.
Professor Dr. K, the Vice Chancellor of this university, Professor Anil Variyat, the Registrar, my learned colleagues of this university, and my dear young friends, and the future of the 21st century India. A very good morning to everyone present here. Before I formally begin my presentation, the NLIU Bhopal is completing 25 years of its inception, and we don't give any memento to any visitor to the campus. We always print this text of the Indian Constitution and present this Silver Jubilee edition of this Constitution with all the amendments to the Vice Chancellor first. And you can also stay back. One to the registrar. Right, before I begin a formal presentation, I think Vedant,
Yes.
you are in the third year.
Yes, sir.
So he beautifully related Sachin Tendulkar's birth on the 24th April, right? And also Kesavananda Bharati. And I was looking at him from there. Without specs, he also looked like Sachin Tendulkar. Right? When he started the first match, right? So he himself has presented Kesavananda Bharati in a nutshell. So we have 3 nutshell presentation of Kesavananda Bharati. And I would like to present the views. To be very frank with you, it is a crime to condense everything in about an hour and 15 minutes or an hour and a half. Because in the law school Bangalore, when we started teaching, Article 13 itself we used to discuss for at least 2 to 3 weeks in a trimester, with every student having the text of the Constitution in their hand. And we don't go by article, article 12 is over, go to article 13 and then 14, no. We always, like monkeys, from one article we jump to another article,
And that is the beauty, when you create that network among the articles, not systematically going through the articles, you understand the beauty of this Indian Constitution. And we used to take at least 2 to 3 weeks to discuss only one article, which is at the center of this discussion today. So therefore, I have divided my presentation in 5 different units. I would request the Vice Chancellor to tell me when 10 minutes is left, so that I can complete, and I will be too happy to take your questions and respond to them. The first one is general comment about the Constitution. Being a student of constitutional law over 40 years. The second one is a formal introduction of this Kesavananda Bharati's case, the prelude. The third presentation, part of the presentation, is Kesavananda Bharati in a nutshell. The fourth one is post Kesavananda Bharati circus that took place. And finally, my concluding observations. That is the way in which I have arranged my presentation. Why don't you be seated? It's a punishment to stand for 2 hours. Right? You can take my seat. Please come. I have no issue. I have no issue. Come. It's all right. The prelude that I would like to take a couple of minutes. Vedant, you please come and occupy this. There is absolutely nothing wrong in it. Please come. Come here. He is afraid of the Vice Chancellor. Right. Please carefully observe my statement here. The Constitution of India is one among the best constitutions in the world. The statement is not complete, and it is one among the worst implemented. So the statement, I start with this, one among the best written constitutions. I have gone through the entire constitution on a number of occasions, right? My language has improved, my understanding has improved, and we always have this cooperative teaching, 3 or 4 teachers, including the former Chief Justices, coming and teaching. So politely we disagree with the observations made by each other, and we also learn from those interactions. The second one is, in this beautiful constitution, best written constitution, I came to the conclusion not because I read only one constitution. I have been teaching comparative constitutional law. I went through 12 different constitutions and felt, including the American Constitution, this is one among the best. In the working of the Constitution from 26th November 1949, because some provisions of the Constitution had come into force, rest of them coming into force on 26th January. So if we take in the last 74 years, so we'll be stepping into Amrit Mahotsav of the Constitution next year. We have committed 3 Himalayan blunders as far as the Constitution is concerned. The first one is, by standalone, it's a blunder. But when you read it with the second one, it becomes an Himalayan blunder. The first one is, there are 3 Himalayan blunders as I mentioned. The first one is, we wrote the lengthiest constitution in the world. Right? And in the judgment, somebody wrote it's the longest constitution. It's not the longest, it's the lengthiest. There's a world of difference between these 2 phrases when we use them. Right? So, lengthiest constitution, is it a crime? If you go through the American Constitution, just about 7 articles, very beautiful. If I give that and then ask you to read it from here to the airport, possibly you can read it once. Whether you understand or not, that's a different thing. If I give the Indian Constitution and ask you to read, you will take it, see the thickness this way, that way. By the time you will reach the airport. Now, is it a crime? It is not a crime, because American Constitution is a federal constitution. There are 50 state constitutions, and if you keep all of them one above the other and place the federal constitution, it will be this much. So considering that, India is really a brief constitution. It addresses both the federal and states together. Is it a crime? Once again, I am asking this question. One state overtook, because nobody likes to stay in the Guinness Book of Record for a long time. So one state overtook us in the 70s. Can anyone suggest which one was it? They wrote a lengthier constitution than that of India. Any guess from the audience? No, South Africa is not lengthier than Indian. They followed Indian constitution in drafting. I'll give you a clue. It is not there in the political map of the world today. Oh, yes, sir. Huh? No? Okay. Yugoslavia. Yugoslavia wrote a much lengthier constitution. So writing a lengthier constitution, it is not that it is going to help the state in any manner, right? And it is not to be seen in the political map of the world today. It got disintegrated into 3 different states. I do not want to get into it. But is it a blunder? I would say standalone, it's not a blunder. But when you combine that with the second blunder, it becomes also a blunder. What is the second one? Second one is, after writing the lengthiest constitution, we the people of India, as the preamble goes, we have not read it. Tell me how many of you have seen the text, how many of you have read the text, and how many of you have tried to understand the text? 3 different questions, right? And I can prove it very easily. At 1.4 billion population in this country, if you take all the law students in all law colleges, in absentia law colleges, right? All the judges, sitting, retired, everyone of all the courts, we do not even contribute to 1% of the population. The people who know law or who are connected to law in some form or other. Out of this, if you try to find out how many of them have really gone through the constitution, you can possibly count, and that is the reason why the Supreme Court and the High Court, they are all deciding the cases the way they want, right? So what is written in the constitution is not followed in practice. Why? Because we the people of India, we are very happy as to what we are. We don't challenge them, we don't question them. The Harvard University Law Journal, by and large written by the students, every judge of the Supreme Court of the US, the moment the publication is released, they would see the journal, whether their judgment is critiqued by anybody. If there is a rationale in the criticism, they wait for a best opportunity to reverse the judgment also. But here, I don't know whether we write such quality articles, thanks to GPT, right? And even if you write, I don't know whether any judge has the time to sit and read your article and refer that, or any lawyer reading that and referring your article, in this judgment. So it's a challenge, right? So when we have not read it, to understand is dur ki baat hai. If you have not read it, to understand is a difficult task. The third one is very important. The third Himalayan blunder. Right from the word go, whether it is 26th November 1949 or 26th January 1950, we have practiced something which is not written down in the Constitution. The judges, the Prime Minister, and if you just see the legal history of India, there was a tussle between the first President and the Prime Minister as to the status of the President, right? And somewhere, because of the dominance of one over the other, they all belong to the same party, right? And Rajendra Prasad contested the election second time, as against the wishes of Nehru, right? Won the election. And he also wanted to contest the election for the third time. And Nehru had to do all the circus possible in the world to convince him and ask him not to contest for the third time. So the conflict which started, the Supreme Court took the side of Prime Minister Nehru And I think from day number one we have derailed from the written phrases of the Indian Constitution. Right? Is it true? Is it good? Is it bad? I do not want to mention this, and therefore the third Himalayan blunder is that the British constitutional conventions are interpreted to look at the written provisions of the Indian Constitution by the courts, and therefore the written provisions do not have any value today. Right? I will just give you two judgments. If you read them, if you find time, please go through them. I am very confident even if you don't understand what they were, your English language will certainly improve. That is how I got improved my English language. Right? Otherwise I have been a Tamil medium student up to my graduation degree in Madras. Right? So when you read, I think you see the language, you try to understand each and every phrase. Two judgments. One is UNR Rao versus Indira Gandhi, Supreme Court judgment. I think when you read, the judges have left the written provisions of the Constitution. Wonderful question was asked, and this is also a very good example for the writ of quo warranto in the Supreme Court. Right? And the judges went to London. In England it happened, so therefore in India it should happen. Then what is the use of this written Constitution? Right? They took almost 2 years, 11 months, 18 days or 17 days, right? What is the use of this? Right? And the second one is Samsher Singh versus State of Punjab, 1974 Supreme Court. And if you read, and in fact Justice Krishna Iyer, who was one among those 7 judges who wrote the judgment, the second year students at NLS, 2 hours, they just questioned him left, right and the center, and he was not able to answer any question. The students kept the text of the Indian Constitution. This is what it says, power of the president. And you say the president has no such power. He has to always act on the advice of the Council of Ministers. Who authorized to do this? No, in England. Why are you going to England? Please come to India. We have the text, please read this. How are you going to get out of these written provisions of the Indian Constitution? He had no answer. So these 2 examples, there are plenty of them, but to cite a few, only 2 of them, please go through that. These 3 Himalayan blunders continue to plague the Indian Constitution and its working. Let us keep that at the background of our discussion. Third one is the doctrine of separation of powers and checks and balances. A doctrine which is very deeply ingrained in the Indian Constitution in number of provisions, both the doctrine of separation of powers and checks and balances. We have not understood the ABC of that. The Supreme Court took 23 years in Kesavananda Bharati, and only 4 judges out of 13 saying separation of powers is also a basic structure. Up to that there was no basic structure. After 23 years of practice, they said there is also a basic structure, and because those 4 judges have said, subsequent judges also started singing the same song. Yeah, it's a basic structure, it's a basic structure. But let me tell you, after telling all this, singing the same song, they have not understood the value of separation of powers or checks and balances. Otherwise, they would not have delivered the Scora judgment. They would not have set aside the, even the Parliament wouldn't have made that law, would not have amended the Constitution. But all these things are tussle between the government and the judiciary. And the third contender, the president, is nowhere to be seen. And if the third contender is missing, then it is a power play between 2 of them. And if you allow one of them to succeed, I think Montesquieu cautioned us, if 2 authorities combine together, there begins the end of liberty. There begins the end of liberty. And for everything we have to go to the court for, exercising our right. Apart from the basic structure doctrine, is there anything called as basic structure? The German Constitution is called as basic law, because the Constitution is the fundamental law of superior obligation. The Constitution creates all the 3 branches of the government and other constitutional authorities. And that itself is basic. And to look at basic, within the basic, Whether it is appropriate or not, I don't know. There are certain articles which can be modified, amended. Hats off to the Supreme Court. After the Menaka Gandhi judgment in 1980, the Supreme Court has strengthened Article 14, 19 and 21 left, right and the center. You have tons and tons of judgments available. We all welcome that. We all welcome that because ultimate objective of any civil society is the enjoyment of liberty, and that liberty is not absolute. It comes with some obligations also, right? And therefore, the Supreme Court has done the work beautifully well in strengthening certain rights and also weakening the other rights. Right to property, for example. If you are all students of 5-year law course in political science, we also teach this. John Locke, the purpose of entering into the social contract is life, liberty and property. It is the duty of the state to protect the property, right? And then you already heard the Vice Chancellor saying, Kanna, observing that it is not a fundamental right. Please ask this question to yourselves. You cannot enjoy any one of the rights without having a meaningful right to property. You may have all the rights, but minus property, right, you cannot enjoy any other right meaningfully. And I would rather say that is the foundation of enjoyment of other rights, and we say that it is not a basic structure. It need not be a basic structure, right? So therefore, we have to look at the other basic issues. It all starts with the interpretation, the basic structure doctrine, with the interpretation of Article 13. Every constitution, written constitution of democratic form of government, they are all called as living constitutions as well as limited constitutions. Why? It limits the power of each and every organ of the state. No organ is given the absolute power to do anything it wants, right? And therefore, every constitution is living. What does it mean? It changes according to existing circumstances by interpretation, right? Therefore, the first written constitution of the modern world, the US Constitution, is celebrating roughly around 235th anniversary. So it has continued. If not properly done, then I come across two different states. Russia enacted the first constitution in a hurried manner in 1918. Within 6 years, they bulldozed the first one, brought the second one in 24. 12 years, again they brought it, the third constitution, 1977, and the present disintegration. If you just take France as an example, where liberty, equality, fraternity, all these things came into picture, they are now facing the Fifth Republic of France. So when you disregard the constitution, which is the basic document, the fundamental document of superior obligation, then I think the danger is that we may be having a new constitution coming into picture at a later point of time. And in political science, we also teach when this constitution fails to deliver, ultimately it is a revolution which will take over, right? The signs of that which we see everywhere, disgruntlement, so on and so forth. So Article 13 Clause 2 very clearly limits the power of the state. How? The state shall not make any law taking away or abridging any of the rights provided in this part, that is part 3 of the Constitution, and if it is done to the extent of its inconsistency, be declared void. Who will declare it as void? The court will declare it as void. It does apply to all the rights in part 3. So you cannot take away right to property and say rest of them are basic, and right to property is not a basic structure. And that is a limitation. So the term law, and that is how the discussion begins. The term law in Article 13 Clause 2, right? The state shall not make any law, and the law is also defined in 13 Clause 3. And it is an inclusive definition. It does not speak about any law made by the Parliament. It does not speak about any amendment made by the Parliament, right? And by saying that Article 13 a law will not apply to Article 368, and an amendment made under Article 368 will not become part of Article 13 is not little, for me it is not digestive at all. Because the citizens of this country have been fooled twice by the court. Once by saying that it is not law, amendment is not law. Right? Please think about it. The judgment they have written, but it is for you and I to think about it and ask this question. Okay, amendment is law, not law, understandable. Can you implement what is not law? If amendment is not law, can you implement what amendment is not law on everyone, on the institutions, on the individuals? And that is why I said we have been fooled twice or misguided twice by saying that it is not an amendment under Article 368, and what is not an amendment will still be a law and still it can be enforced, is something that we need to look at it, right? So therefore, the Constitution itself has number of features like this. I will possibly refer to some of them as I proceed. Before I come to this Kesavananda Bharati, let me just begin with one or two observations. There were two judgments written by the Madras High Court. One is Champakam Thorarajan versus State of Madras, the other one is Venkatraman versus State of Madras about employment, one is about education. The Madras High Court very clearly interpreted in accordance with the Constitution, everyone needs to be treated equally. So the communal GO issued by the government of Madras is wrong, and set aside that communal GO. And similarly, the employment and then many of these land reform legislation set aside by the court, because right to property is very important. And then even before the first general election took place, the Constitution was born, right, for all practical purposes 26 January, and within a year the Constitution was amended by the interim legislature, because the first general election took place only in 1952. If the philosophy was so sound, they could have done it even at the time of drafting the Constitution. They could have expected all these things. They didn't. They amended the Constitution, and that is how the Constitution, I call this as, are you recording this? Because sometimes I speak something which you can digest, the court may not digest. The judges may not digest. The parliamentarians may not digest. I call the 9th schedule as the waste paper basket of the Constitution. Right? Because when the first amendment was made to protect all these things, they inserted Article 31A and 31B. So all the land reform legislation, in an attempt to protect, they could have made some amendment there itself and said any law seeking to protect land reforms will be protected. Finished. You create a basket in the form of 9th schedule and keep on amending the Constitution every time the new legislations come into picture. And then once you have tasted the power, Lord Acton was absolutely marvelous. Power corrupts, and absolute power corrupts absolutely. Right? And they started putting, Tamil Nadu started putting the reservation, right, more than 50%. It is unconstitutional for other states. For one state it is constitutional. What nonsense is this? Right? Why the other states they don't have? Madhya Pradesh has more tribal population. Chhattisgarh has most tribal population. What sin they have committed? And they started putting regulations. Companies regulations, this regulation, that's why I call it as a waste paper basket. The legislation which were sought to be protected, ultimately it has lost the steam. They are putting every law and regulation to protect, including the most important, which I will be discussing with you, Indira Nehru Gandhi versus Raj Narayan. Right? Such a wonderful judgment. If you read, hats off to the two judges in Allahabad High Court who set aside an election with courage and conviction. Right? But that courage and conviction was not there in the Supreme Court when they tried to balance it. Right? I will come to that little later. So this is how 31A and 31B came into picture. 31C came into picture. 31D, and 31 has been truncated and removed. So the foundation on which A, B, C, D came, 31 itself is non-existent. Right? We have to question all these things as students of law. Right? Now they also started interpreting. Let me just, because the first speaker, Vedant himself, has identified these cases, I will not spend more time on that, but I would like to just give in a nutshell some important aspects. Shankari Prasad was decided in Shankari Prasad versus Union of India was decided in the year 1951. It's a constitution bench, 5-judge bench, and the 5 judges were unanimous because they all loved Prime Minister Nehru was called as Chacha Nehru, right? So all the judges also felt the Chacha was doing something right, and therefore they were unanimous in saying that Article 13, the term law is limited only to legislative law, not to a constitutional amendment, which means through the constitutional amendment the parliament can amend any part of the constitution, right? And even to destroy the constitution, if they do it, there is nothing wrong in it. And that's what they attempted. I'll come to that. It is not that they have left it, right? What started in 1951, that the time and again, being a student of both political science and public law, both constitutional and international law, I enjoy integrating the ideas that I have learned from all the three. And it said, in the exercise of ordinary legislative power and does not include an amendment made under Article 368. That is the beginning of everything. And the lawyers pleaded, no, there are certain features, though they didn't use the term basic structure or essential feature or whatever it is, and you cannot do that. But they said, Article 368 amending power is done in what you call it as the exercise of constituent power. Please carefully listen to this. In the exercise of constituent power. What is this constituent power? It is the power equivalent to that what is exercised by the Constituent Assembly. Right? It is equal to. Right? And can it be equal to? Please see the preamble. We the people of India. Right? We have given the constitution. Last phrase, adopt and give to ourselves this constitution. It is not given by any Congress party, Communist party or BJP to us. Right? And you may question this, because when I was invited by the US State Department when they were celebrating 200 years of their constitution, right? 2 of us were selected from India. I was lucky to be there. And there one senator, a black senator, made a beautiful statement. When the constitution was adopted in 1788-89, which came into force, they forgot to include my name because there also it started, we the people of United States of America. They forgot to include my name. A senator speaking like this in the 200th anniversary. Why? Because the disparity, the inequality between black and white, among the whites, white male and white female, that disparity was writ large. Even today it is there in some form or the other. Right? And therefore, Edmund Burke had a beautiful statement. So, can you say, I think many of you were not born in 1950. Even I was not. Right? Is there anyone who is super senior? Right? So, can we say, the term we the people of India does not include any one of us? And Edmund Burke beautifully puts it. The state is nothing but a partnership agreement. Please carefully listen to this. The state is nothing but a partnership agreement. A partnership agreement between those who are lived and gone with those who are living and those who are yet to be born in this world. See what a beautiful statement. We the people of India, it's a continuous process of those who lived and gone with those who are living and those who are yet to come. And the entire environmental jurisprudence that you are talking about, sustainable development, is looking for the future. Is looking for the future so that we could save some of these things for the generations to come. Right? So political philosophies are wonderful lessons. We miss them. Because we see political science, how is it relevant to law? We don't go to the classes. Right? But if you read that, let me tell you, there is a deep connection between If you are able to read that, you are able to understand law much more than what you are now. Right? Okay, anyway, that's a different issue. So, therefore, Article 32 will not affect amendment made under Article 368. Unanimous judgment. Fine, in those days, I don't know whether even judges had the privilege of, reading the Constitution leisurely. And the judges, by and large, what do? They listen to two sets of lawyers possibly. And within those parameters, they tend to decide. It is not that their understanding comes into picture based on whatever is given in the limited time. It took some time. Again in 1965, another case came into picture challenging the inclusion of certain amendments in the waste paper basket. That is Sajjan Singh versus State of Rajasthan. And that is what Vice Chancellor was trying to say. There was a division in accordance with Article 145, Clause 5. The judgment need not be unanimous. Every judge has the right to dissent and write a dissenting judgment as well. And for the first time, the two judges dissented from the majority view expressed in unanimous opinion of the Constitution bench in Shankari Prasad. Right? 3 of them still agreed with Shankari Prasad. 2 of them beautifully expressed their dissent. I would like to just mention that Justice Hidayatullah, just one sentence each. Right? Justice Hidayatullah said, the Constitution gives so many assurances in Part 3. Constitution gives so many assurances in Part 3. He has not mentioned Part 4. My colleague Professor Devidas will say the entire public policy is present in Part 4 of the Constitution. We seldom read those articles which are relevant, and therefore we try to interpret the way that we need it. Article 37, I just deviate a little from this and tell you. Part 3, the provisions contained in this part, that is Part 4, I am reading Article 37, right, shall not be enforceable by any court. Then we don't read further. Right? It's not enforceable by any court. What is the use in reading? Right? But it is for the legislators to read. It says, after that comma, it says, but the principles therein laid down, please carefully listen to me, the principles therein laid down are nevertheless fundamental in the governance of the country. It is not over yet. And it shall be the duty of the state. How many of us know about this? It shall be the duty of the state to apply these principles in making the laws. In making the laws LAWS, not LOWS. Right? Now we don't read that. So he speaks only about Part 3. Nothing is mentioned about Part 4. No, I think you have to appreciate. If Part 4 was implemented effectively, one example I'll give you. Article 45, what a beautiful statement it was, original constitution, original provision. All children, it is not Hindu children, Muslim children, Christian children, no division. All children up to the age of 14 shall have free and compulsory education up to the age of 14 years. And that shall be achieved within 10 years from the commencement of the Constitution. Within 10 years of the commencement of the Constitution. It went out and how many years, how many decades, and finally somewhere the court said it is a fundamental right. Then the parliament also woke up, yes, it is fundamental right, and amended 21A, inserted 21A, freedom, right to education is a compulsory. Right? Why? We could have implemented that properly and effectively. Population was less, budgetary allocation could have been given. That is why the state's obligation under 37. And in 90s, one government said, Operation Blackboard. What is that? Every government school will have at least one blackboard. There may be number of classes, but one blackboard. 5-year plan. Wonderful. And next 5-year plan, every school will give chalk piece, Operation Chalk Piece. By the time they give the chalk piece, the blackboard has vanished. So effectively, and what is the use in giving 21A and say, oh, Supreme Court has done a wonderful job? So you please think about all these things. It is not simply talking about the Constitution. think about it and whether this is true or not. And then he says the Constitution gives so many assurances in part 3 that it would be difficult to think that they were the playthings of a special majority. Beautiful statement. It is a plaything of a special majority, referring thereby the 2/3 majority mentioned in Article 368. It cannot become a plaything for the special majority, right? Justice Mudolkar, right? Whether making a change in the basic features of the Constitution would be regarded merely as an amendment or would in effect be rewriting a part of the Constitution. Rewriting part of the Constitution. If it is the latter, the question would be whether it is within the purview of Article 368 or not. So, two of them expressed very clear doubts about the unanimous judgment delivered by the court in Shankari Prasad. And that led to the most important, dynamic, in my opinion, one among the best judgments delivered for two reasons. The Chief Justice was Justice Subbarao. I want to bring some politics also into this before going to Kesavananda Bharati, so that the foundation is clear and you are able to appreciate what was done in Kesavananda Bharati and what has been done after Kesavananda Bharati. In Golaknath versus State of Punjab, the Chief Justice was Subbarao, one among the most brilliant judges, right? A statesperson, judicial statesperson. He constituted 11-judge bench. You just imagine, there was a 5-judge bench in Shankari Prasad, in Sajjan Singh. If you want to overrule, you have to have 7-judge bench. He had the freedom to constitute judges, pick 7 judges. That is what the Chief Justices do. Constitution of the bench is a prerogative. I should not use prerogative. It is the authority given to. Prerogative goes with the crown. In the Indian Constitution, we should not even use the term prerogative. It's a power or authority given to the Chief Justice to constitute the bench. But he constituted 11-judge bench because he knew some of the judges, if they are picked up, possibly will go the other way around. And therefore, a 11-judge bench was created. And in this judgment, the validity of the First Amendment, 4th Amendment, 17th Amendment, they were all questioned. And the judges beautifully said, the previous benches have declared them as constitutional. And if we now say it is unconstitutional, all these cases that were disposed of earlier will come back to the court and clog the judicial process. Is it not an intelligent forethought that the court had and said, we stay with that. We are not going to do anything. Up to this point, these things have been held constitutional, let them be held constitutional. But henceforth, here afterwards, you cannot do that. Why? They said amendment is also law under Article 13, right? And that changed the entire edifice, right? I want to mention this. After 1965, it was the death of Nehru in 64, and then 2 years down the line in 66, 67, Lal Bahadur Shastri went to Tashkent and he died there. Then the Congress party was in crisis, right? So Congress party was divided into Congress A, B, C and Z. I think how many divisions they came, we don't know. But it took consolidation immediately. And when it took consolidation, that was the time when the government becomes weaker, the judiciary becomes stronger. Right? You please, whether this economic inversion model will work here, it works. Systematically it works. When the government is stronger, the judges keep quiet. And when it is weaker, the judges become a little stronger. And this is one such occasion where the 11 judges, out of which 6 judges declared that we will not discuss about the old judgments, they will stand as they are. For the first time, they issued an order of implementing a doctrine called as doctrine of prospective overruling. This judgment will not affect the past judgments, but it will apply only to the future from the date of this judgment. And the application of the prospective overruling doctrine itself, I call that as an intelligent judgment delivered by the court. Otherwise, it would have created lots of confusion. Please take a note of that. And then they also said categorically, if law includes a constitutional amendment under Article 13, the Parliament, this is the place where it came into conflict with the legislature. The Parliament shall not have any power and will not have any power to amend any of the provisions contained in Part 3 of the Constitution. Right? It was a categorical statement, and then immediately the Congress party consolidated. Indira Gandhi became the Prime Minister, and then we had another political development. Before I come to that political development, can the judges of the Indian High Court and the Supreme Court be impeached? How many of you say that they can be impeached? Nobody has been impeached, but the process has been initiated. How many of you feel that the judges of the Indian High Court and the Supreme Court can be impeached? Only few. What about the rest? Let me tell you, the judges of the High Court and the Supreme Court cannot be impeached. The only one person who can be impeached under the Constitution is Article 61. Only the President can be impeached. All others are removed by the President by an order issued by the President, including the Vice President. So you cannot use, please don't use the newspaper language. The newspaper language is impeached. No judge can be impeached, they can only be removed. There is a world of difference between these two. The language of 61 says, the moment the second house passes the resolution, the President stands impeached. Right? That's all. There is no other appeal. Whereas in the other one, President and other constitutional authorities, including CEC, it says, after the resolution itself prays to the President to remove that person from office. And the President has to issue the order to remove that person. So therefore, this to remove the person, an act has to be passed by the Parliament. Article 124 authorizes the Parliament. By law, you have to do it. This law was not made in 1950, 1952, 1955, but ultimately it was made in 1968. What is the reason? Judges Inquiry Act, Judges within bracket Inquiry, INQ, right, not EN, Inquiry Act 1968. Why was it passed? With the intention to remove possibly the Chief Justice Subbarao and teach him a lesson. But it also took 1 year. No, these are all history, these are all part of history. You can read it. It is not that I am telling you some cock and bull story. It took 1 more year for the government to frame rules under the Judges Inquiry Act that came into force in 1969. By the time the judge was able to understand that something is going to happen to him, and he negotiated with the opposition political parties, resigned the position as the Chief Justice of India, contested the election, lost the election, went back home happily. Otherwise, he would have become the first judge to have been removed from office in the history of Indian Republic. Right? So you should understand 68 has some connotation. It is because something happened there, something is reflected, and then slowly but steadily the concept of committed judiciary got rectified. Slowly but steadily. And it came to the fore in 1973, right? The law minister, the prime minister, everyone speaking about we want committed judiciary, which will toe the lines of the policies of the government. And the moment that happens, the concept of checks and balances will go through the nearest window. That's it. right? It was too dangerous, and therefore this created some ruckus. Then comes the second political historic event that took place, that is the 1971 Indo-Pak War. Right, the war lasted for 18 months, 18 days. Right, December 1st to December 17th, everything was over. 93 prisoners of war were there in India. India respected and sent them back to Pakistan, right, peacefully, right, and Bangladesh was born. And in India, an emergency was declared when the war was happening, emergency based on war with Pakistan under Article 352. The war was over, the emergency was not removed. The emergency was not removed. It continued. It continued up to 1975. And in 1975, another emergency was proclaimed by the President under internal disturbances. That was a phrase used in Article 352 that was amended later by the Janata Party as armed rebellion later. Right? On internal disturbances in 1975, many leaders were arrested. I think that's politics. Right? In between 1971 and 1976, the Constitution was amended left, right and the center. Starting from the Constitution 24th Amendment Act, right, 1971 to 42nd, change the number, 42nd Amendment Act in 1976. How many amendments? If you calculate, 18 amendments in less than 6 years, at a rate of 3 amendments per annum. So the legislature, the parliament was doing a wonderful job at that particular point of time. And what did they amend? That's, amendment is okay, record is okay. What did they amend? If I read the 24th Amendment, which I brought a copy also, and also the 42nd Amendment, right, it will tell you the story. I will come to that little later. And before I get into Kesavananda Bharati, this is the, basic history which will help us in understanding what happened and why it happened, the way that it happened. 4 or 5 propositions I would like to mention before I get into Kesavananda Bharati. Right? The first proposition is, which I already mentioned, Constitution as a fundamental law of superior obligation. And then I would like to refer to 2 Privy Council judgments. The Privy Councils were also having the appeal from Australia, Canada and all Commonwealth countries. After the Supreme Court decides something, a final appeal can also go to Privy Council. India also had that, but they gave up the Privy Council the moment we were born as an independent nation. Attorney General Ontario versus Attorney General Canada, a Privy Council judgment of 1918. And the judge said beautifully, 5 judges, the Privy Council, please don't come to look at the British constitutional conventions because there is no law. You have drafted the Constitution. You go according to what you have written. Don't come to us. And they said very prettily one sentence which we cannot and we should not forget. If the provisions of the constitutions are explicit, that is final as to what you can do and what you should not do. Right? Very, very, it's a common sense. But the common sense comes through the Privy Council if the phrases in the written constitution are explicit. In English constitution, there is no constitution. Nothing is explicit. They are all based on the conventions. You see how the Prime Minister was changed peacefully. Here, things would have been entirely different. Right? So therefore, you cannot imbibe those constitutional conventions. We are not mature enough to that extent. Right? So therefore, this is what the Privy Council said. And it also did the same thing way back in 1964 with reference to Nigeria. Very beautifully they reiterated the same thing. They went on to say don't come to British constitutional conventions. And what did our Indian judges do? 1971, 1974, you go to British Constitution. Krishna Iyer wrote, it is neither Thames nor Potomac. The Riverian, example. Why should you go to America and you read our Constitution first? You interpret what the Constitution says, not what British Constitution says, what American Constitution. You may have certain qualities imbibed if it is absent in India, right? So therefore, that is the first one. Second one is 13.2 argument. Law includes constitutional amendment. I told you we have been fooled twice by saying it is not law. If it is not law, still it is being implemented. The third proposition, Article 368 itself has certain limitations. 13.2 is a limitation. State shall not make any law. It is a limitation on the parliamentary power. Article 368 clause 2 says, if you have to amend 5 different provisions provided in clause 2, right, that I don't want to read all of them, right, including the president, the powers of the court, including Article 368, not only the parliament, half of the states shall also ratify it. Half of the states can also ratify it. Sometimes there was a law minister, Bharadwaj, who became the governor. He is no more, a very good friend of the law students and the law teachers, very warm person he was. And he was the law minister when the 52nd Amendment Act was passed, which took away the powers of the High Court and the Supreme Court. And if he took away after the passing of the bill by both the houses, the law minister gives a press report, right? And are you sending it to the states for ratification? He said yes, it has to go to states for ratification. But he drove directly to Rashtrapati Bhavan, got the signature of the president. The president also did not apply his mind. He signed it. It became a law. And next day morning, the same press people went and asked him, sir, yesterday you said you are sending it to states for ratification, and now you have got the president's assent. He said, I don't see any reason why it should be sent to the states for ratification. So the entire clause 2, wherever the jurisdiction of the High Court or the Supreme Court are violated, right, you have bypassed that procedure also, and then the amendment is popularly known as anti-defection law. And ultimately the Supreme Court in Kyoto Holland and versus Zachilu, please read the minority judgment. It's a 3:2 judgment. Read the minority judgment of Sharma and Verma brothers, right? And beautiful judgment. And they used the doctrine of severability to constitutional amendment for the first time. So no doubt if you remove that jurisdiction part of it, there is no need to send it for ratification. And therefore we uphold that 52nd Amendment as valid. Whether it is right or wrong, I will leave it to your judgment, right? But we need to look at this. The fourth argument is constituent power, which I have already mentioned. And finally, please carefully listen to me. The Parliament is a creature of the Constitution. Parliament is the creature of the Constitution and the law. The Representation of the People Act says how many members should be there. It's a creature of the Constitution and the law. And the creature cannot be given the authority to destroy the creator. I hope you understand what I am trying to say. A creature of the Constitution, whether it is executive, legislature or judiciary, cannot be permitted to destroy the creator here being the Constitution of India. I hope I am clear, right? If you have any doubts, please make a note of it, we will discuss. Then comes His Holiness Kesavananda Bharati, Sri Padagalavaru versus State of Kerala, right? 24th April, Sachin Tendulkar, right? We remember everything. There were 13 judges. I would like to highlight the names of two of them. Justice A.N. Ray, Justice M.H. Bain, who dissented on many occasions in this judgment. And the best judge who wrote the best essay got the position. Right? See, I am not saying this is what Palkiwala said. The student who wrote the best essay got the position. Right? And that is the peak of it. When I was a student, I think you are also, I don't know whether you have studied this moral science. We used to have a discipline called as moral science. We read a story. The story is Five Blind and the Elephant. right? The 5 blind wanted to, feel how the elephant looked like. So they went to the elephant, and one was feeling the trunk, the other one was looking at the tail, feeling the tail. They touched different parts of elephant, and they understood only that part, right? And that example I would like to extend it to Kesavananda Bharati, 13 blind and elephant, right? 13 blind and elephant. When you don't search for the truth on the written provisions of the Constitution, everyone said this is basic structure, that is basic structure, right? If I have to get into the details of that, I think I'll take lots of time. In fact, I have brought all of them, right? What is basic structure for each and every one of them, right? Supremacy of the Constitution, do they have to say this as a basic structure? I don't know. Republican and democratic form, that is what preamble says, is it not a basic structure that we know? Separation of powers, I told you already, but never ever spoke about it up to that point of time. Secular and federal character of the Constitution, finally in S.R. Bommai, it got reflected. In spite of the fact, Dr. Ambedkar very categorically saying on 25th November 1949, Indian Constitution is no doubt a federal constitution. But the judges took 23 years, 40 years almost in, right, saying that it is federal. Otherwise, we followed very British authors. It's a quasi-federal. Quasi-federal means neither they have understood what is federal, or they have understood what is unitary. They are in between categories. They don't understand either of these two. And we spent 40 years in this, right? So therefore, these are all aspects. I will not get into the details of what they said. It's a voluminous part in going through. Ultimately, it was Professor Upendra Bakshi who mentioned that even 13 judges have not read the judgment in full. What they wrote, they did not read. And somewhere he categorically mentioned, I am the 11th person to have read the judgment in full. So we mentioned this in the classroom, and one student called Lakshmi Narayan, I remember all those names. After a week, he stood up in the class, sir, you can count me as the 12th to have read the judgment. Because, voluminous, mountains of papers were used, rivers of ink, for what purpose, I don't know. Right? So therefore, this gives us an idea, and they have arranged what was in question. The question was the validity of the 24th Amendment Act, 25th Amendment Act, 26th and 29th Amendments, 4 amendments. The SEC reporter classifies the judgment in 8 different parts. One is the basic groundwork of Constitution of India. The second one is directive principles of state policy versus fundamental rights. The third one second one is preamble, third one is DPSPA versus fundamental rights. Fourth one is Article 368, scope, ambit, content, extent of amending power. The fifth one was 24th, sixth one was 25th Amendment, seventh one was 29th Amendment, and eighth one was miscellaneous. 26 they didn't mention, but ultimately they said it will be decided by a constitution bench. Alright, so they disposed of 26 very easily. But they looked at this arrangement. I am not going through all of them. I would like to just mention the view of majority. It is not 7. Sometimes you have to take views of others, the fence sitters sometimes, as positive, right, or negative, depending upon how you read it and how you analyze it. I put it as 9, right? Justice Sikri, Shelath, Hegde, Grover, Jagmohan Reddy, Palekar, Khanna, Mukherjee and Chandrachud. On one side, the other two, the different points expressing the dissent. They have the right under Article 145, Clause 5, no doubt about it. Now comes the content, which you are all waiting for. I took so much of time to lay the foundation, right? I have put it under 6 different categories, views of the majority, right? Golaknath case is overruled, right? So the intention is to overrule Golaknath. But please, as students of law, please let us question, did they overrule? I would rather say, this statement was written only to please the authorities outside. In other sense, Golaknath was limited only to part 3. Kesavananda Bharati extended it beyond part 3, including part 3. Of course, right to property, there were certain disputes, but excluding property issue, they were also saying equality is there, liberty is there, these are all basic structure, all these things. So, the statement that Kesavananda Bharati is overruled, in my opinion, is to satisfy one group, that they have been successful, right? But as students of law, I question this. Did they overrule? I would rather say they expanded the horizon of the power of the parliament not to amend the constitution by inventing the doctrine of basic structure. They expanded it, they have not minimized. Please carefully look at it. So I challenge or I question, I have no one to challenge, I can question the first statement of the majority that Golaknath is overruled. Right? How they overruled? They also did it because when it comes to 24th Amendment, they said it is valid, and that is the place where they overruled, Golaknath. Number 2, which the authority did not like. Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. Right? What is the basic structure? The court will decide depending upon the circumstances, what is and what is not. So in 70s, what is basic structure may not be a basic structure in 90s or 2023. You can, because law is dynamic, it can keep on changing, right? Then comes the third assertion: Constitution 24th Amendment Act is valid. And please open your minds, carefully read Article 368 as amended by the 24th Amendment Act, right? Completely changing the edifice, completely changing the picture. What is meant by Parliament? Parliament consists of 2 houses of Parliament and the President. What is the status of the President? On par with both the houses. And then they changed the title. It was procedure to amend the Constitution. They changed the title, power and procedure. Right? And then they also said, notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power. So 24th Amendment brings in the notion of constituent power. Whose power is it? Parliament's power. The Parliament may, in exercise of constituent power, amend by way of addition, variation or repeal any provision of the Constitution in accordance with the procedure laid down in this article. Any part. So part 3 is also part of this. They can amend any part of the Constitution. Preamble was not considered to be a part, but in Kesavananda Bharati they said preamble is also a part. So to prove that they have the authority to amend, they amended in 1976, added secular, socialist, and then integrity, all these things which were part of India even before that. Right? So therefore this is number 1. Then clause 2, that is very, very important. After passing through the procedure, it amended, it shall be presented to the President, please carefully listen to me, it shall be presented to the President, who shall give his assent. Who shall give his assent. Earlier it may be sent to the President for assent. President has the power because the President is the only authority along with the Governor, only 2 people in the Constitution who undertake the oath in the provisions of the Constitution to preserve, protect and defend the Constitution. Not the judges. The only authority, the President and the Governor, they take the oath to preserve, protect and defend the Constitution. And now you have also made him the villain, who shall give his assent. He cannot say no. Right? Who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill. Right, 24th Amendment. It also included one more clause, clause 3, and it also amended Article 13 and inserted 13.4. What did it say? Nothing in Article 13 shall apply to any amendment made under this article. And similarly, they went to 13.4 and amended that provision. Now, when the Supreme Court gave a final approval that it is valid, and we were all reeling under emergency 1971 to 77 till the elections were conducted, the 42nd Amendment also came into picture. It inserted 2 additional clauses to Article 368. What are they? Clauses 4 and 5. I would like to bring it to your notice. Please carefully listen to this statement. The content of clause 4. No amendment of this Constitution, including the provisions of Part 3, made or purporting to have been made under this article, whether before or after the commencement of Section 55 of the Constitution 42nd Amendment Act, shall be called in question in any court of law on any ground. Finished. You cannot even go to the court. You cannot call the amendments passed earlier or after this amendment in any court of law on any grounds. So if your fundamental right is taken away, you cannot challenge it anymore. And then they added a concession, not a concession, an explanation in clause 5, right? And for me it is little hilarious to read it. Anyhow, I'll read it. For the removal of doubts, if you are not able to understand the content of clause 4, we are removing your doubts by this provision. It says, I'm not saying, I'm reading it. For the removal of doubts, it is hereby declared that there shall be no limitation. I told you Lord Acton was proved time and again right in Indian context. So once they have tasted the authority in 24th Amendment Act, constituent power, now they have bulldozed everything, and you just can't question. No limitation whatever on the constituent power of Parliament to amend by way of addition, variation or repeal of the provisions of the Constitution under this article. Thank God. 76 it was passed, 77 the election was conducted. The Janata Party ABC came into picture, and 2 years they also amended the Constitution, 44th and 45th. Whatever was done in all these amendments, they tried to reverse it, right? And ultimately in 1980, in Minerva Mills versus Union of India, it was not a question of the constitutional validity, it was about the Minerva Mills being taken over by the state, but they used that opportunity and declared clauses 4 and 5 as unconstitutional, because judicial review is a basic structure of the Constitution. So some solace. Otherwise, now I can go to the court, right? Otherwise I cannot go to the court. So clauses 4 and 5 have been declared as unconstitutional using the doctrine of basic structure, right? And that is why immediately after the judgment was delivered, one among the persons who understood the judgment was Indira Gandhi and the law minister. And the Chief Justice was summoned. This story was told to us by Justice Krishna Iyer in the class. They were summoned to the Prime Minister's house for a tea, and the Chief Justice was afraid of going alone. So he took Justice Krishna Iyer also, and after the tea it was offered that he should constitute a larger bench to review Kesavananda Bharati. And he looked at Krishna Iyer agreed, nodded, and he also agreed. They came out. And we asked, why is it that you said yes? We'll see. A larger bench was appointed. It met, and ultimately nothing came out of it. Because every time some judge retired, you have administrative procedure to nominate one more person, and somewhere after that things, so the review did not take place, and that gives us an idea as to the 24th Amendment to 42nd Amendment, how things have gone wrong. And then they said the part of section 2A and 2B of the Constitution, 25th Amendment was also valid, and 25th Amendment, as I mentioned, right, that is right to policy on giving effect to directive principles of state policy. I will not get into it. And they said the Constitution 29th Amendment Act is also valid, right, and the Constitution bench will decide the validity of the 26th Amendment. This is the content of the judgment. Two judges, Justice A. N. Gray and M.H. Beg, expressed their, I will not go into what they said. In 1973, three judges were superseded, Justice Hegde, Grover and Shellett, who delivered a majority opinion in Kesavananda Bharati. So if you say that you don't want to be a committed judge, we will teach you a lesson. And they taught the lesson. And three brilliant judges resigned because they couldn't, under their junior, they don't want to work, right? So there was no collegium at that particular point of time. So they resigned and left. And A. Andre took over. Somebody asked the question, why did you, you should have also said I don't want to take. If I say, the next person will accept. If I say no, if possibly Dr. Uke says no, I am there to accept it. Right, so I have accepted, justification, wonderful judgment, right? On his part, he accepted it. And then in 1975, M.H. Beg was appointed superseding H.R. Khanna. One among wonderful judges the country had, right? But anyhow, wonderful is only in the judgment, but beyond that we will not look into, right? So therefore, Justice Khanna, I just wanted to bring it to your notice. Although it is permissible under the power of amendment to effect changes, however important, and to adapt the system to the requirement of changing circumstances, it is not permissible to touch the foundation or to alter the basic institutional pattern. Basic institutional pattern. The word amendment postulates the old constitution survives without loss of its identity despite the change and continues even though it has been subjected to alterations. So you make certain changes, but the foundation will remain as it is, right? And that is a beautiful statement given by Justice Hegde. Very quickly in the next couple of minutes, I know time is up. There is a plethora of judgments, one after the other. I will not get into the details of all these things, right? One stray instance that came out was Indira Nehru Gandhi versus Raj Narayan, 1975 judgment, which created some ruckus, right? But see the beauty. On appeal, she went to the Supreme Court. During the pendency, it was not implemented. The judgment was not implemented. She amended the Constitution, 39th Amendment Act, inserted Article 329A, right, and also amended the Representation of People Act, and through the 39th Amendment Act inserted this Representation of People Act 1951 in the 9th schedule, the waste paper basket I was referring to. Basically it was meant for land reforms. How is the Representation of the People Act connected? We don't know. And this amendment was given retrospective effect so as to cover the corrupt practices committed by her at the time of election. So literally what they did was, the judgment delivered by Allahabad High Court was nullified by this amendment made. Of course they took some time. Ultimately they declared that 39A was also unconstitutional a little later, but things developed. Then came Minerva Mills, I already mentioned to you. Sambamurthy versus State of Andhra Pradesh, 1987, right? These are all judicial review as a basic structure. L. Chandrakumar versus Union of India. Maybe, once I am a free bird out of this NLIU, I would like to, I will request the Vice Chancellor if he can permit me to come and teach some critical constitutional law, not the basic constitutional law, critical constitutional law for 2 weeks I'll make you read and understand what the text is and how it is being practiced, and I will try to do that. Kyoto Olahan versus Chilu, L. Chandrakumar versus Union of India, and these are all on judicial review as a basic structure. Then came Scora, the last judgment of 2016. In fact, my PhD thesis submitted in 1994. I have critiqued the first Scora judgment, because the first time the Supreme Court spent more than 10 pages on explaining what is meant by constitutional convention, and the moment they explain more, you can come to the conclusion they are going against it. That's what they did. Right? I tell the students, please don't read it. There may be 300 pages. Go from the backward. Please look at the paragraph which starts with the phrase however. And that is a place where you read. Right? Rest of it is only assembly. The Supreme Court said this, in this case, the Supreme Court said in that case. And that I don't think we have to repeat ourselves. But however is the most important. And the Supreme Court finally in 2016 said, independence of judiciary is a basic structure. I am extremely sorry when critical constitutional law comes. I say the independence of the judiciary is deeply ingrained in written provisions of the Constitution. Unless and otherwise the Parliament touches that. The Parliament has never touched any one of them. I don't know why they were worried about the independence of the judiciary. Right? But please also, ladies and gentlemen, listen to this. There is a clause 7 to Article 124. A judge who has been on the Supreme Court cannot plead before or act before any authority, which prevents all the judges from taking up any positions. But things have changed, right? And whether the Supreme Court was over-instating or reinstating or over-reinstating independence of judiciary to justify the collegium system is something that we need to look at it. Then there was a dialogue whether basic structure could also be applied to an ordinary statute. Right? I don't know, because the statute is looked at based on the parameters provided in the Constitution. And however, the judges said, yes, there is nothing wrong in it. So you can also look into. And finally, in I.R. Coelho versus State of Tamil Nadu in 2007, they said, yes, it's possible, even statute. And earlier, they said that the judgment delivered in Vaman Rao, any act or regulation included in the waste paper 9 schedule, on or after 24th April 1973, right, the judgment date, alone can be protected. Up to that point, it can be protected. Thereafterwards, you can also challenge the validity of those acts or regulations inserted, right, in that. And then you have S.R. Bommai secularism as basic structure, right? Let me just quickly, in the last 2 minutes, few concluding observations. What did we understand? We understood that power corrupts, and absolute power corrupts absolutely, and Lord Acton needs to be saluted. Second observation, if separation of powers and checks and balances are not respected as present in the Constitution with all the 105 amendments even after that, right, one branch will become all powerful, and that is the beginning of end of liberty as given by Montesquieu. Third, in the context of legal illiteracy present in this country, I am using the term legal illiteracy, even among lawyers, teachers and students. I am not worried about any consequence arising out of that, right? So the legal illiteracy, the judiciary should seek to remain within the bounds and do its duty properly to interpret what the Constitution is, rather than doing something different, right? And remain within bounds, right? I'll just deviate a little. I think you all travel by aircraft and buses. You have a common handrest, right? And you look at the person who is going to come and sit next to you. If the person is little slim and small made, you occupy the entire handrest. If the person is taller than you, little hectic, then I think you tend to withdraw. And that is what will happen in the separation of powers. I already mentioned, if the government is powerful, the other branches keep quiet, right? And if the government is weak, they also play the role. But what is expected in the constitution is to remain, take off of that handrest, allow the other person. The concept of checks and balances is politely to remind when one organ breaches its limit, crosses the limit, gently telling them, nudging them, please don't do that, come back to your normal level. And that will make the constitution even more effective. And then the fourth observation, everything is basic structure except what is basic to the constitution. In political science we teach there are three essential functions of the state. I will not go to the other two. One among the essential functions of the state is administration of justice. And today if I go to the court, I don't know whether even my grandchildren will get any relief. If that is not a basic structure or the essential feature of administration of justice, and I would appreciate if we could write to the court to look into and see, fix that, if it is a criminal case, after 6 months the evidence is distorted. So you have to have a limit that within 6 months or 1 year you have to dispose of the case. Civil case within 2 years. The fast track commercial courts cases, I don't know how much time they are taking. Election cases within 6 months, but they seldom do that. So you should have some certainty within which at least I can get justice from the courts. I would consider that as more foundational to the edifice of the constitution rather than in periphery searching for what is basic structure. I don't want to join as the 14th person to look for what is the shape of the elephant, right? And then finally, I would like to conclude by what Dr. Upendra Bakshi has very beautifully put in one of his articles about the judiciary. Please carefully listen to me. If you do not apply brakes, the engine of amending power would soon overrun the constitution. With this, I would like to thank all of you for your patient listening for the entire period. And I also would like to thank the Vice Chancellor, the Registrar, and all of you for giving me this opportunity to come and share some of my thoughts with you. Thank you very much.
Thank you very much, sir. A very interesting quote which you said that 9th schedule is the waste paper basket which I take from this lecture. Which I would definitely use in my future. So now the floor is open for the questions. One by one you can ask.
So one essential
Yeah.
actually a clarificatory question on the debate going around that you briefly mentioned, so about legislation also being tested on BSc.
Yeah.
Sir, as just a second term student of constitutional law, I don't understand the requirement of it, because I mean it's rather redundant. A legislation is supposed to be based around the constitution. Constitution is the contour of what a legislation can be, and then why do we need to test it for the, I mean it's a test for the foundation and we are applying it to the product of the foundation.
Yeah, I think if you also read the majority judgment in Kesavananda Bharati, they also don't agree with this, right? The veracity of a statute is to be looked at, please be seated, whether they have the authority to pass the law. You look into Article 245, read the entries, right? And then apply those interpretative doctrines, so on and so forth, and decide. Number two, whether it takes away any of the fundamental rights of the individual, you check the veracity of that statute based on whether it violates any of the fundamental rights. Third one, whether it violates any of the provisions of the constitution, apart from the requirements, entries, whether it also violates any of the other provisions of the constitution. These are the three tests, in my opinion, which can declare a statute as unconstitutional. But now what the court said is, please also look at it from a broader perspective. All the amendments that were inserted in the 9th schedule after 24th April 1973 can be tested against the basic doctrine, basic structure doctrine, because you cannot still challenge those entries which are already there. You got the point? So you have two levels or two different streams of the 9th schedule, something that you can question and something you cannot question. And therefore they use possibly the basic structure doctrine to allow you to question or challenge those statutes. Yeah.
So, one, we are referring for these legislations on basic structure for only pre-1973 legislations that were put in. So why can't we just check those legislations in terms of those constitutional amendments? Because those constitutional amendments could be invalidated. Why go to the legislation?
I don't know whether you can challenge the veracity of the statute as against any amendment made.
So the amendment puts it in the 9th schedule, right?
Which amendment? That amendment, yes.
The amendment puts it in the 9th schedule, and the concept of the 9th schedule itself.
No, please wait. The amendment puts in a set of legislation, not one legislation. So which legislation are you questioning? Are you questioning all the...
So, but a part of a legislation comes...
So you are once again going to the part of that amendment, not the entire amendment.
Right. I'm saying any legislation that we feel is problematic as per the constitution, we can challenge it on the angles of the constitution.
Yeah, fine. I got your question. Please be seated. Take for example, one amendment inserts 13 statutes and regulations to the 9th schedule. You are challenging only one act or one regulation. Let us presume the court says that it is unconstitutional. It will not affect the validity of the remaining 11 statutes and regulations which were inserted by that amendment. So if the court says that the amendment is invalid, the entire list of statutes and regulations will go. So you have to look at that way of interpreting to preserve the constitutional amendment and also eliminate the law which is against the basic structure. Right? Okay. Anyone else?
So I've got a second question about the 9th schedule itself.
Okay, go ahead.
So 9th schedule, the creation of the 9th schedule, you also refer to it as a waste paper basket.
That's my comment, yeah.
Right, that's your comment. And I have read the history of how the 9th schedule was created. And the concept itself that something can be, it can't be as well judicially. Now that's also against the basic structure.
Yes.
But we allow it to happen post 1973 itself. I want your opinion on it. Why?
That is the price we pay for our ignorance.
So whose ignorance?
Our ignorance.
As the people?
We the people of India. That's why I told you, the Supreme Court made amendment is not law and still that amendment was enforced. Right? No, that's the way, when you look at it as a lawyer, you see there are certain incongruities which I cannot accept. But still successfully they imposed all the amendments on us. Yes? Yeah. Please pass on the microphone to him.
I had a question, so if I may ask for...
Yeah, please, yeah.
So sir, when we talk about the comparative study of the constitutions, so sir, if we talk about the US Constitution and the case, it started with the Lodgeners versus State of New York, wherein year after year the regulations and the statutes that were passed were struck down by the court. So sir, how do you see that? How have we fared in terms of the breaching the line between the executive and the judiciary crossing the line, wherein there are always talks that you should stay within your limits of the constitution?
That's a good question. I think already I mentioned to you the judgment delivered by the court in 1974, Samsher Singh versus State of Punjab. So between 1950, the moment we became a republic, till that point of time, the two other branches, the legislature and the judiciary, joined hands and made the executive weak. They said the executive cannot do anything. In England there is a saying, if the handkerchief of the crown falls down, she has to seek the permission from the Prime Minister to pick it up. I don't know, we can be so slavish in a constitution which we have given to ourselves. But this is what literally the court did. So they have finalized. Now, Please, that is why you have to take all the three branches together. It is dynamics among the three branches. If one is silent, then the other two branches, they start fighting amongst each other as to prove who is superior. You got the point? And I try to do something which I think as final. I send a list of names to the government. The government says, no, we will not approve this name. Right? Because ultimately it is the president who has to sign. So therefore, the tussle is between the legislature and the judiciary. It is very dangerous to look at the setting aside of the constitutional amendment and the NJAC Act. I do consider NJAC Act it's unconstitutional on very different grounds. I have written a 11-page comment because the Supreme Court wanted the opinion from the citizens. So my opinion is one among the 524 people who have written to the Supreme Court, and the Supreme Court bundled it. After a few months, sent it to the Law Commission for storage. Right? So this is a struggle, unless and otherwise, because the Supreme Court has said in 73, separation of power is basic structure. Please look at all the decisions. Every judgment today says separation of its basic structure. Are we respecting the executive branch as written in the text of the Constitution? The discretionary power given to the President and the Governor, are we following it? Then you will find the answer. Right? Yes, sir.
Sir, my question is regarding after the Kesavananda and Bharati was the judgment was given, we had the 44th amendment which gave that if a referendum is passed with 51% of electoral college, then even the basic structure of the constitution can be changed.
Where is the electoral college?
As far as I have read it.
There is no process of referendum in India.
No.
There is absolutely. The referendum is available in few states. Smaller states where the population is less.
On national level it is not.
Absolutely no.
Okay, sir. So
and even if there is a referendum, it will be based on party politics. It is not the individual voting. I am a member of X party, so I vote whatever the party says. We lost our ability to think and act. And that is why when the first removal opportunity came, the legislature could have prevailed over the judiciary by removing Justice Ramasamy from office. Again the party politics played. One party said, requested the members to abstain from voting, and they did not get the 2/3 majority, so it has gone. The second case in Soumitra Sen, the Rajya Sabha gave a full report, and then on Saturday morning he sends a fax to the president saying that he has resigned from office, and then immediately how fast they act. Monday morning, Meera Kumar was the speaker, and it was scheduled to take up as the first item to discuss, and she made a brief statement. As the judge has resigned, there is nothing that remains in the resolution. Who authorized them? Almost 8 years after the retirement of Warren Hastings from India, his impeachment proceeding was taken up in the House of Commons. It is not to remove somebody from office. It is to make them ineligible for other offices. Now take for example Ramasamy has been removed from office. He contests the election to become the president and wins. That you can prevent. Somebody is getting the pension, we will not give you the pension. So it is also liabilities to tell them for others to behave properly, and that we have failed also. So that check and balance which is supposed to happen is not happening, and because it is not happening, now the judiciary has upper hand in dictating certain terms and conditions. Right? Okay. Anyone else?
Sir.
Yeah.
So I have two questions.
I'm
First
afraid.
is have been waiting. Yeah. So the first question is applicability of basic structure in general laws. So we have case of Kuldeep Nair where it was held that it is not applicable. But then we have the case of Madras Bar Association in 2014 where Justice Kera Malhotra said that it is applicable, superseding the precedent. So do you think that it should be applicable on the statutes, the legislatures? Because time and again we see politicians saying that this particular act, law is violating basic structure, but as per Kesavananda Bharati it is only applicable to the amendment. So
Are you taking moot courts also seriously?
yes.
Huh? Okay, so you seem to be reading some judgments. Good, that's nice. I would like to rely upon what the Supreme Court judge said in Kesavananda Bharati. What is basic structure We will decide depending upon the circumstances. We are not bound by our own judgments. Right? We will decide what circumstances. Sometimes we may overrule what was discussed as basic structure earlier. We may now say, no, it's not a basic structure. That authority we still maintain, and that's right. And that's what is happening in the reference that you are giving.
Right. So the second question is basic structure and fundamental rights, where Justice Siddhartullah in the Sajjan Singh dissent said that basic fundamental rights cannot be amended. This was his opinion. Then further we have Justice Nariman recently saying that fundamental rights should be as basic structure, and he equates basic rights and fundamental rights as equal. But now when we study in jurisprudence, we realize that there is a fundamental difference between the word basic and fundamental. So how can we solve this dichotomy where Justice Nariman says that I equate basic structure and basic rights as fundamental rights?
Yeah, fundamental right has a particular meaning. That's, I think, very beautifully explained by Dr. Ambedkar. If your right is violated, any right given in Part 3, you have direct access to the Supreme Court of India. You don't have to go to the High Court, waste your time and then go on and appeal. And that's why it's called as fundamental. Nowhere it's called as fundamental right. In the US, if your right is violated, to go to the Supreme Court, you can go to the Supreme Court only on second appeal. Please carefully listen to me. Only on second appeal. But here, I can directly go to the Supreme Court. That's why it's called as fundamental. Number two, basic of rights is an emerging concept based on human rights issues. Food, shelter, water, right? These are all essentials without which no one can live. They are all citizens. And that is basic right. We are not talking about those basic rights in fundamental rights. The Supreme Court has interpreted all these basic rights as part and parcel of Article 21, life and personal liberty. So they are basic rights, right? So I think we need to understand the jurisprudence in that sense. There is a clause, and I think the Supreme Court did right. That's why I said hats off to the Supreme Court after Maneka Gandhi. Right, left and the center, right? They have strengthened our freedom, and they continue to do so, and that's what is expected of them. But when they play with the dynamics of the inter-institutional agencies created by the government, why should the Supreme Court say your appointment of Chief Election Commissioner and other election commissioner for 73 years nothing happened? Now we will decide the Chief Justice also needs to be consulted before you appoint. I would consider this as tangadana bolta na, right? Kabab mein haddi. That's my feeling. I may be totally wrong, but I seriously consider that it is not right, because if what they say is true, then they should also accept the appointment of judges is also done like that. Before the collegium came. And after collegium came also, still they continue to do it in some form or other. So these are all things which we need to look at it in that sense. Right? Okay, anyone else? Okay, thank you very much.
Thank you very much, sir, for your robust and exciting, knowledgeable lecture. We take back a lot of things from you today. Now I invite upon the Director of Center for Public Policy and Law, Professor Dr. Pratap Salunke, sir, to deliver the vote of thanks.
Thank you very much. Dr. Vijaykumar sir mentioned about two things. One, that is the price of ignorance, and second is about the liberty. Judge Learned Hand has very meticulously quoted that liberty lies in the hearts of the people. If it dies there, then no law, no code, and no constitution can revive it. And that's why what Harold Lasky has cautioned us, that the eternal vigilance is the only price that we pay for the liberty. And that's why this lecture and the takeaways from the lecture that we can easily measure, which is a litmus test. It is always said that the test of a good lecture is when it ends here, it starts there. and the questions which we received on this very topical issue, that is a very important and litmus test to determine how this triggering of a thought process that happened to this lecture. So thank you very much, sir, for accepting our invitation and shedding light on this very important issue. So I'm really thankful from bottom of my heart for this session. I'm thankful to our Vice Chancellor, sir, for allowing us and doing all the necessary things to seek Vijaykumar sir's assent for this particular lecture, and constantly guiding us for making such kind of events a grand success. I am thankful to our Registrar Dr. Anil Variyat sir for extending wholehearted support for organization of such kind of programs. I am thankful to Assistant Registrar Academics and as well as the admin for extending all the support. I am thankful to admin staff, library staff, all the faculty members, and definitely the student, because it is very well said, an individual can blow a whistle, but it requires an orchestra to play a symphony. So this was a symphony which was played. So thank you very much once again. I request all the students to stay back, and I request the dignitaries, they can proceed. Thank you.